Today's topic also we have kept, normally we keep the topics wherein the student of law and the practitioners can understand, even for the judicial officers. And that, keeping in view that, we have kept the topic section 313 of the power of CRPC, of power to examine the accused. Amongst us, we have Justice R.B. Budhial, a former judge of Karnataka High Court, who has also been closely associated with Karnataka State Judicial Academy. And plus, at the same time, after demitting the office of the Karnataka High Court, he is now in the Karnataka State Administrative Tribunal, which itself shows that what a multifaceted personality in perspective of sharing his knowledge is, where one is taking the and deciding cases in respect of service matters, and out here we are deciding and sharing, not deciding but sharing knowledge in respect of a criminal law, where as a practitioner, as before we're going live, I was discussing with Mr. Budihal that how important facet it is. And if one understands as a lawyer for accused as well as from the prosecution, that how it can be used and what are the ways forward in this respect, as to whether the inquiry or trial, how it has to be gone forward, as to whether that accused could be administered oath in respect of this, what are his rights, whether he can deny being asked such questions, whether he can be time and again called for all these perspectives. These are the broader areas which, with his vast knowledge, we would be going across with him and understanding the law so that we can become a better lawyer and a better student of law. Though we all say that as a lawyer, we are always a student of law, even the judicial officers are as such. Without taking much time, I know that it's a working day tomorrow for lawyers, and it's also the working time for the office right now. But the fact that people are connecting with us only reflects how immensely popular Mr. Budhial is for his knowledge sharing. Over to you, sir.
Dear brother Vikas ji and all my brother and sisters who have joined this webinar lecture. Today the topic assigned to me is power of the court to examine the accused under section 313 of the CRPC. First we have to go, what are the wordings of this section? What exactly is the section under the CRPC 313? I can say that this section totally consists of 5 clauses, and we can go all the five clauses one by one, so that it will be easy for us to understand what exactly this section means. It starts with clause number 1. In any inquiry or the trial, for the purpose of enabling the accused person to explain the circumstances appearing against him, the court may, then this clause number 1, it is having 2 subclauses A and B. The court may at any stage, without a previous warning to the accused person, put any questions which the court may deem it proper. Clause number B, what it says, the shall, after the examination of the prosecution witnesses was over and before calling the accused person to enter into the defense, has to put the questions in general to the accused person. This is with regard to clause number 1. I have already told clause number 1 of section 313 consisting of 2 subclauses. In the clause number A, subclause A, the word used is may. The court may, but whereas in clause number B, the court shall. So there is a mandate or the duty cast upon the court so far as 313 clause 1 subclause B is concerned. And clause number 2, it speaks of no oath is to be administered to the accused while he is going to be examined under the section 1 clause subclause B is concerned. Number 3, clause number 3, what it says, the accused is not responsible for any punishment for refusing to answer the questions put by the court or giving a false evidence, false answers to the questions posed by the court. This is clause number 3. And clause number 4, what it says, whatever the answers given by the accused person to such questions shall have to be taken into consideration during the course of the inquiry or the trial. And then also the answers can also be used for or against the accused person in any other inquiry for inquiring the other offences, so that the answers given by the accused person, they speak that he has committed such offences is concerned. That is with regard to clause number 4. Now coming to last clause, clause number 5 is concerned, while preparing the questionnaire to be put to the accused person, the court can take the assistance of the prosecutor as well as the defense counsel and then prepare the questionnaire. And even the court can permit the accused person to file his written statement in compliance of this requirement. These are the 5 clauses which were there under section 313 of the CRPC. With this background, now we have to consider what is the law with regard to this 313 section is concerned, how the court has to consider these aspects, and whether this examination of the accused under section 313 can it be said to be a mere formality or it is with some specific object. About all these things we have to make some reference. You please see, in the old criminal procedure code, in place of section 313, there was another section that was 342. So far as the subclass 1 is concerned under section 313, proviso was inserted. What is that proviso? In summons cases, if the court dispensed with the appearance or attendance of the accused to the proceedings, so also the court may dispense with the examination of the accused. This is pertaining to only summons cases are concerned. This proviso was added subsequently. Why? Because so far as the summons cases are concerned and whether the examination of the accused under section 313, whether it is must or it is optional or the court can dispense with this aspect is concerned. Earlier, what happens now, there are divergence of opinions by the different high courts. Some high courts were of the opinion that even in the summons cases also, the examination of the accused under section 313 is must. But there is some other view by the different high courts that there is no such a necessity so far as the summons cases are concerned. The court can dispense with the examination of the accused person so far as the summons cases are concerned. But subsequently, what happens now? The proviso came to be inserted to section 313 subclass 1, and I have already submitted the proviso. What it says, so far as the summons cases are concerned, when the court dispense with the personal attendance of the accused person to the proceedings, so also the court is having the power to dispense with the examination of the accused under section under subclass 1 B is concerned. But what it says now, in this regard, there are judgments of the Honorable Supreme Court, because when the provision is there, personal attendance can be dispensed with by the magistrate court in case of summons cases are concerned. Then naturally what happens now, court used to examine the accused person through his counsel. Answers will be through the mouth of the accused, the counsel who is appearing for the accused person. But the Supreme Court, in 2 decisions, it has made certain observations. The first case is in the year 2004, AR 2004, page number 524. You can please note. AR 2004, page number 524. In this particular case, the name of the case is also that you can take K. Anbalagan versus Superintendent of Police is the name of the case. Name of the party is involved in that particular case. The Supreme Court said, the Supreme Court observed in that particular case that the courts are liberally that allowing dispensing the personal attendance of the accused person and the counsels are allowed to answer the questions framed by the court, but the Supreme Court said it deprecated such a practice to be followed even in case of the summons cases also. Supreme Court said if there are such reasons, such exigencies, then in that case that can be done. But in all the cases, if that is the followed, it is not with the in the object that is going to be achieved by introducing section 313 of the CRPC, that is the Criminal Procedure Code, is concerned. The Supreme Court has also gone to the extent of making a observation that when such applications are filed before the courts, the prosecutors are not going to object to such applications. Therefore, a comment, the serious remark is made against the prosecutors why they are not raising their objection, insisting that the accused personally must come before the court and to answer such questions is one of the cases that we have taken into consideration. And there is one more case, that is AIR 1969 Supreme Court. AIR 1969 Supreme Court, page number 381. And the name of the party you can take down, Bibhuti versus State of West Bengal. Bibhuti versus State of West Bengal. In that case also, the Supreme Court said, it insisted that the examination of the accused through the counsel, it is not feasible, it is not advisable, and it is the personal attendance of the accused person is the necessary in the case. Because you please see, in clause number 1, when you made a reference, what are the words? In any inquiry or the trial, for the purpose of enabling the accused person personally to answer. The word used is personally. Earlier, if this word was personally was not there. Subsequently, the word was inserted in the clause number 1 of the section 313, clause 1 of the CRPC. When that clause is inserted in the section, it is with some object. If the accused himself come before the court, it is necessary for establishing a dialogue directly between the judge and this accused person. In what way it is going to help? You may ask the question. Suppose a client, he wanted to give a case to the lawyer. The client himself has not come before you. Suppose he wanted to file a divorce petition against the wife. He has not come before you. He sent somebody by signing the wakalat and some papers. You are getting the instructions from the mouth of that person who is a middleman, and you are preparing the draft and filing before the court. But if you call the party himself, the husband himself before you for getting the instructions personally from him, it makes a lot of difference. You may agree or you may not agree, but it makes a lot of difference. He can say what exactly the facts involved in that particular case according to his own personal observation. Therefore, it becomes very easy for a lawyer to prepare the draft, to prepare the case, and he can file before the court. Therefore, when the accused himself personally appear before the court, then establishing this link or the link, establishing link between the judge and the client, personally if that is there, judge can pose some questions, he can get some answers to those questions. Then it becomes very easy for the judge to meet all his contentions while he appreciating the evidence adduced by the prosecution witnesses, and it is easy for the court to pronounce more satisfactory and substantial judgment by the courts of law. This is with this object. Introducing section 317 of 313 of the CRPC for examination of the accused before the court is, it is with this the particular object that was inserted in the CRPC. Therefore, Supreme Court repeatedly said in many of the decisions, if there are such the exigencies, then it's all right. In exceptional circumstances, if suppose the accused it is not able to come before the court because of his physical disability or incapacity, all right, you can record through the mouth of the advocate. But Supreme Court said so far as the warrant cases are concerned, then it is always feasible to record the evidence, record the answers directly from the mouth of the accused person, and it is not advisable to record the questionnaire or the answers through the mouth of the lawyer of that particular accuser is concerned is the observation made by the Supreme Court. And from that date onwards, because of such decisions, which I have referred to decisions, important decisions about the practice which was prevailing, and the Honorable Supreme Court made comments and advised that it is better to get the accused person personally before the court and you can examine him. This is one object. Now, the object of section 313 is concerned, it is enabling the accused person to meet all the incriminating materials which were occurring in the evidence of each particular witnesses. That is the object. And it cannot be said that while examining the accused person under section 313, if you pose the questions as if that you are putting him under the cross-examination, whether it is allowed. It is not with the object of cross-examining the accused person, but it is with an object to give him an opportunity to explain the incriminating material appearing against him during the course of the evidence. That is the object. Therefore, you cannot put him into the nail. You cannot put him into the position of you are as if cross-examining the accused person. That is not the scope and ambit of section 313 of the CRPC so far as the examination of the accused is concerned. Now the question comes, if you say that accused, he is giving, suppose he has given the confessional statement while examining the questions under section 313 of the CRPC. Confessionary statements were made by the accused person. Whether such a confessional statement, while recording the evidence, recording the statement under 313, whether such a statement can be relied upon by the court for the purpose of conviction of the accused, is the one important question. Yes, anybody? Anybody? Now, before putting the answer, you please see, you come to one provision in the Indian Constitution, Article 20, Subclass 3. What it says? What it says? It deals with the principle of self-incrimination. An accused person in an offense cannot be a witness against himself is the principle under Article 20, Subclass 3 of the Indian Constitution. Now the question is, when during the course of examination under section 313 of the CRPC, accused is making some admissions of the confessional statements, whether the principle under Article 320, the Article 20 Subclass 3, whether it is going to be affected is the main question. Yes. Is there any inconsistency between 313 CRPC and Article 20 Subclass 3 regarding the self-incrimination principle? Yes. Law says there is no such inconsistency. Section 313 of the CRPC is not at all inconsistent with the principle under Article 20 Subclass 3 of the Constitution. This is why, because you please see, the accused is making these answers to the questions not under an oath. When it is not an oath, it cannot be treated as an evidence which is defined under the Indian Evidence Act under Section 3. I have already told during my last lecture what is the definition of the term evidence under the Indian Evidence Act. Section 3 I have already dealt with, consisting of two classes. Class number 1, it deals with the oral evidence, and class number 2 of section 3, it deals with the documentary evidence. I have already told. Therefore, the courts deliver the judgments that this section 313 and answers given by the accused person to the questionnaire, even if they may be admissions or the confessions of the matter in issue, the section 313 cannot be said to be inconsistent with Article 20 Subclass 3 of the Indian Constitution. Therefore, this is the settled position of law. Because in this case, what happens now, as I have already told, the answers given were not on oath. And secondly, there is no any compulsion on the accused person. It is left to him. Question will be read to him. It is left to him whether he has to answer, as he can be keep mum also. He can be keep mum also. There is no compulsion. And apart from that, he is not making these answers before the police officers during the investigation, but it is during the course of the trial, that too before the judge in the court of law, he is giving the answers. Therefore, even if such a confessionary or the admissions of the fact and issue in that case is concerned, such statements are made by the accused person, then such a statement can also be relied upon by the court while considering the case as against the accused person is the principal, so far as the confessionary or admission, the statements made before the court during the course of examination under section 313 of the CRPC. Now, the next question will be, suppose he made some admissions or the confessionary statements during the examination under section 313, whether that evidence can be the sole basis for conviction of an accused person. Suppose there is no other evidence, but in his examination he has admitted certain important the aspects, material facts. Can it be sufficient? Can it be a criteria or the sole basis for conviction of an accused person? Only on the basis of his answers. Yes. You know that what is the difference between the evidentiary value of the confessionary statement and also the dying declaration under the Indian Evidence Act. If there is a dying declaration satisfactorily proved before the court, even if all the witnesses turned hostile, but if the dying declaration has been established to the satisfaction of the court in accordance with law, that can be the sole basis of conviction is the law, so far as the dying declaration is concerned. But same is not so far as the confessionary statement of an accused is concerned. Why? Why the difference? Confessionary statement admitting the guilt, even if it is made before the court, but the law from the judgments of the Supreme Court as well as the legal aspect, what it says is that cannot be the substantive piece of law. It cannot only form the basis, sole basis of conviction. So it requires the corroboration from other materials also. Admissions or the confessions only during the course of examination under section 313. Only on that basis, court cannot proceed to convict the accused person, stating that you yourself admitted. And the court has to see the corroboration from other sources. If the other sources are also consistent with his admission, then in that case, what happens now? It is for the court to rely upon such confessionary or the admissionary statements, and the court can proceed with the matter, pronouncing the judgment, even it may end it in conviction of that particular accused person is concerned. This is the law. Now, with regards to the non-examination of the accused under section 313, or the examination it was not properly done, what will happen? What is the effect on the entire trial is concerned? Non-examination of the accused under section 313. So for that, the law, what it says, if the judge or the court not examined this accused person so far as the incriminating circumstances appearing in the evidence of prosecution witnesses as against him, such evidence cannot be used against the accused person. It cannot be used against the accused person because you have not given an opportunity for that fellow. You have not asked him that PW1 in his evidence he has stated like this, incriminating circumstance. What you say about this? If such an opportunity is not at all given to the accused person, then the law says such incriminating material not put to the accused person during the course of examination, it cannot be made use against such person is the law. And the next aspect from the judgments of the Honorable Apex Court, because of the non-examination or the examination is not properly done, whether the trial proceedings are going to be vitiated, or can it be a reason for the courts to pronounce the judgment of acquittal of an accused person is also the consideration for our purpose in the today's discussion. Now it all depends upon that simply because he has not been examined under 313, or the examination of the accused person under 313 is somewhat defective in nature, it is not properly examined. That by itself per se cannot be a ground for acquittal of the accused person. Supreme Court said that it is for the accused person to establish, because of such non-examination and because of such defective or not proper examination, what is the prejudice that has been caused to him. in what way his interest is going to be affected. He has to establish the prejudice. If after analyzing all the entire material, in spite of the defect to the examination, in some the respect is concerned, that if there is no prejudice is going to be caused to the accused person, in that case, what happens now? The Supreme Court said it is not a ground for the acquittal of the accused person. At the most, what the courts can do in order to correct this, the judgment can be set aside, the matter can be remitted back to the very trial court to start from the stage of recording the statement of an accused person under section 313 of the CRPC. The defect can be cured, then the judgment can be pronounced after such recording, after the remand of the case to the trial court. This is the procedure feasible as observed by the Honorable Supreme Court in many of the decisions, instead of pronouncing the judgment of acquittal only because of such defects is concerned. This is one aspect. Secondly, suppose in a murder case, there are eyewitnesses. They have deposed before the court in support of the prosecution case that we have seen this accused person, and it is he who committed the murder of the deceased. He committed with this weapon. MO material object is also identified before the court. There is such an evidence. But the witnesses have not spoken about the motive. Motive means why he has committed that murder. There is some motive for every person. Motive is an impelling power in the human being. It forces the person to commit the particular crime. That is the motive. Suppose during the course of examination of the accused person under section 313 CRPC, no questions were posed regarding the motive aspect is concerned by the court. What will happen? If questions are asked, not framed by the court regarding the motive aspect, but questions are framed so far as the eyewitnesses, the evidence is concerned, they are read over to the accused person. What do you say? For this, first you have to have the background of law. This motive, where it comes under the Indian Evidence Act. Section 8 speaks. It speaks about three things: motive, preparation, and conduct. Motive, preparation, and conduct dealt with by section 8 of the Indian Evidence Act. But here in the case, the example which you have taken, whether non-framing of the question with regard to the motive aspect is concerned, whether it vitiates the entire trial or not, is the question that we are now considering. You please see, I have already brought to your notice that there are eyewitnesses account is there. Some 2-3 witnesses have personally witnessed the incident. They have come before the court and fully supported the case of the prosecution that we have seen, and even they identified the weapon also. Then in that case, what happens now? The law is to the effect that it will not cause any prejudice to the accused person, and on that ground the trial is not going to be vitiated. Why? Because wherever there is a direct evidence, motive, it will not figure. Motive will not figure. For what motive he has committed the murder, we don't know. We are not concerned with that. When the eyewitnesses are there, they are speaking firmly before the court, consistently before the court, that we have seen and he has committed the murder, matter ends there. For what purpose he has committed, we are not concerned with the motive aspect. But suppose if the eyewitnesses are not there, if the case of the prosecution completely rests on the circumstantial evidence, what will happen? Whether can you say that here the motive, even in the circumstantial evidence, the motive will not figure here? Are you going to say like that? But here what happens now? Motive becomes important because case rests totally on the circumstantial evidence. There are no direct witnesses at all. When case entirely rests on the circumstantial evidence, what do you mean by circumstantial evidence? What is the nature of circumstantial evidence to be proved before the court? Supreme Court, in one important decision, they laid down the proposition about this circumstantial evidence. You can take the name of the case, Umed Bai versus State of Gujarat. Umed Bai versus State of Gujarat is the case. And in that particular case, that is, I can give the citation also, AR 1978, Supreme Court. And here the name of the parties, Umed Bhai versus State of Gujarat, 1978 Supreme Court AIR, page number 424. You please see what is the definition that has been evolved by the Honorable Supreme Court so far as the circumstantial evidence is concerned. I can repeat the words of the Honorable Supreme Court in that particular judgment. What the Supreme Court said: it is well established principle that when a case completely rests on the circumstantial evidence, all the circumstances must be inevitably and exclusively suggest the guilt of an accused. You please see the wordings. It is well established principle that in a case wholly rests on the circumstantial evidence, all the circumstances inevitably and exclusively must suggest the guilt of an accused. And there must be no circumstance which is reasonably to be considered the innocence, which is reasonably considered that it is consistent with the innocence of the accused person. And further, the Supreme Court said, even in the case of circumstantial evidence also, it is the bounden duty of the court that court has to consider all the circumstances together and appreciate the integrated whole. It means court has to consider the entire cumulative effect of all the circumstances, not in isolation. One circumstance, like that, you cannot separate the circumstances. That is the principle. And if there is any missing link of any one of the circumstances to form the chain of circumstance, it is a very fatal thing to the prosecution is concerned in the judgment of the Honorable Supreme Court in that particular case, that is Umed Bhai versus State of Gujarat, on the circumstantial evidence. Suppose if the case entirely rests on the circumstantial evidence, the requirement of the law, so far as section 313, examination of the accused is concerned, all the circumstances must be put to the accused by framing the questionnaire. Each witness coming before the court and he is speaking, one witness is speaking about one circumstance, another witness coming and he is speaking about another circumstance. Suppose in a circumstantial evidence, you might have heard that last scene theory you are considering. Last scene theory, that accused person, he has been seen with the company of the deceased person. That is the last scene theory. This is also one of the important circumstances for connecting this accused person with the guilt. Like this, different witnesses are speaking about different circumstances. In that case, what happens now, the requirement of law, all the circumstances must be put to the accused person during the course of his examination under section 313 of the CRPC, and whatever the answers given by the accused person, they are to be taken into consideration while deciding that particular matter is concerned, is also one of the important aspects when the case is totally rests on the circumstantial evidence. And earlier I made the distinction that the dying declaration and the confessional statement made by an accused person, how they are to be treated, but at the time of the examination of the accused under section 313. I have already told dying declaration can be the sole basis of conviction if it is satisfactorily proved before the court, but not so with regard to the confessional statement, and court, it is in need of some other the corroborative evidence along with the confessional statement. This is why, because the dying declaration principle that we are studying, you know that it is not our principle, it is the principle of English law. Dying declaration is the principle of English law. It is not Indian law. But however, the principle of English dying declaration we have borrowed and incorporated in our Indian Evidence Act under section 32 clause 1 of the Indian Evidence Act, which what it says, it never uses the word dying declaration. Section 32 clause 1, what it says, statements relating to the cause of death or circumstances of any transaction in which death is resulted. That is a relevant piece of evidence and it is admissible in evidence. Why it is so? Why the dying declaration can be the sole basis of conviction before the court, even if there is no corroboration from any other evidence? It is because we have to see the basic principles on which this doctrine of dying declaration or the principle under section 32 of our Indian Evidence Act is based. One judge, a British judge, in one case, R versus Woodcock is the name of the case. R versus Woodcock, it is the case of 1789. wherein what happens now, there was a declaration made by the wife because the husband assaulted her and he has caused the injuries on the throat and he has caused injuries on her other parts of the body. Before her death, she made some statements or declarations. Now the question comes before the British courts whether these declarations can be relied upon by the court. For this, C.B. Iyer, the judge, one of the judge in that bench, he laid down the principles, basic principles on which this dying declaration is basing. What he says, 4 words he has said. These are the declarations made at the point of extremity, when the declarant is at the point of death, when motive for speaking falsehood is completely silenced, and when the mind is influenced by most powerful consideration to speak the truth. This is the reason. This is the foundation as per the English law regarding the dying declaration, that a dying man, he never says lie. He never says, he only speaks the truth. That is the principle or the foundation. That is the solemnity. That is the reason the courts can rely upon directly on the dying declaration if it is satisfactorily proved. But requirement is that when we are discussing about this 313 Cr.P.C. with regard to the examination of the accused, even with regard to the dying declaration, whole details, the document which is marked as a dying declaration recorded by the doctor in the presence of the doctor in the hospital, or even it may be in the village, because you know that there are forms of the different forms of the dying declaration. Either it may be oral, it may be written, it may be by making signs. Like that, there are many kinds of dying declaration. But when court relies upon such a dying declaration as against a particular accused person during his examination, you have to narrate all those things in his examination under section 313. You have to frame the questionnaire in such a way that there should not be any confusion for the accused person at the time of giving the answer so far as the dying declaration is concerned. This is how the courts have to deal with the matter so far as the framing of the questionnaire at the time of examination of the accused in the course of the trial is concerned. But now what happens now? Let us come to the practical situations. As a judge of the Karnataka High Court, when many appeal matters come up before me, and when I was sitting before the Honorable Senior Judge also in a division bench, we noticed in many cases that the framing of the questionnaire, it was not, the judge has not at all taken a serious consideration about these things. In a very casual manner, the questionnaire is going to be prepared. Take for example, in one particular case of murder, suppose there are 10 the accused persons involved. So far as 2-3 persons are concerned, there is no direct participation in committing the murder. 3-4 accused persons, their role is only conspiracy with other accused persons, 120B of the IPC. So for example, take another accused person's role is concerned. What is the role? 2-3 persons after till the murder is committed, they have not in the scene. But after the murder is concerned, in order to screen this dead body, taken this dead body from the spot to some other place to screen the evidence, then such person's help is taken. If that is so, what is the relevant provision under the Indian Penal Code, section 201 of the IPC? That is the only thing. But even if such a thing is there, but while preparing the questionnaire, suppose 10 accused persons are there, though the role played by each of the accused person is different in nature, and accordingly the witnesses have deposed in the deposition. But even then, what the courts, that in many of the cases that we have noticed is, the stereotyped the statement is going to be prepared in respect of all the 10 accused persons. It was not necessary. It was not at all necessary. Whatever the evidence as against him, only with regard to that incriminating evidence, you have to pick up that material and you have to frame the questionnaire and read to that particular person. If a person's role is only transporting the dead body to some other place for the purpose of screening the evidence, then in that case, if you read the questionnaire, that you on the spot you have there, you are holding this axe, committed the murder of this person. If you read like this, the questionnaire, just like the other accused persons who have participated, then it is useless. It is not at all necessary for that particular accused is concerned. His role is not at all participating in the actual commission of the offense. Therefore, these aspects and the niceties, they were not at all looked into in many the cases. But that should not happen. That is the concern. And in this regard, I will come to that aspect. I am relying upon one judgment of the Supreme Court, wherein the remarks were made of this tendency or the laxity in preparing the questionnaire for the examination of the accused is concerned. In that, the decision which I wanted to rely, it is from the state of Bihar. It is from the state of Bihar, wherein the Honorable Court observed in its judgment, the Supreme Court judge, observed in its judgment that in a murder case, only one question that was framed, and it was read in the judgment of the Honorable Supreme Court. What is the question? Have you heard the evidence of the prosecution witnesses? What you wanted to say? Two questions are framed. Only two questions are framed. First question is, have you heard the evidence of the prosecution witnesses examined? Second question, what you wanted to say to the questionnaire? Only two questions in a case of murder. Therefore, the Honorable Supreme Court made its comments very severely. And it has been observed that this is happening more. This laxity is more in the state of Bihar. Therefore, the Honorable High Court was asked to take into consideration these aspects seriously. And the Honorable Judge, who was in charge of the Judicial Academy at Bihar, the copy was also ordered to be sent to that particular in charge judge of the Judicial Academy to look into all these niceties. Such things should not happen. And the relevant questions, they are to be framed as against the accused person, basing upon the incriminating evidence appearing against him. Then it will be easy and it will be useful for the accused person to give his answer. So also it will be helpful to the Honorable Court also while deciding the case is concerned. This is how the Honorable Supreme Court came very heavily so far as this aspect is concerned. Now the second aspect, suppose you are reading the questionnaire. Of course, you have prepared it very nicely in the manner that evidence was deposed, and you are reading to the accused person. But if he has not answered, if he is silent, what is the indication of the silence of an accused person? Not answering the questions framed under section 313 of the CRPC. What is its indication? The Supreme Court in one recent judgment, it has observed, and the Supreme Court ruled in that particular case, if there is a silence on the part of the accused person, then in that case, under section 114 class G of the Indian Evidence Act, adverse inference will have to be drawn against such accused person. Adverse inference will have to be drawn, meaning thereby, if had he answered the question, that answer of an accused person will go against him. This is the reason that he withheld the answer. Therefore, the Supreme Court said it is an indicative that if he did not answer the question, it should not be ignored lightly. Supreme Court said that it is to be taken into consideration and adverse inference can be drawn against the accused person. You may say that there is no any duty cast upon the accused person because in clause number 3, we have already read. If the accused person did not give answers to the questions, or if he give the wrong answers, false answers, then he cannot be punished only on that basis. That is the clause we have already read, clause number 3 of section 313. But thing is that, you please see, in some of the cases, there are such a situation wherein he is under duty to speak. May not be in all the cases. For example, you take one accident case, 279 and 338 of the IPC is concerned, if such offense has been committed. In that case, what happens now? Suppose the witnesses came, none of the witnesses, they have not supported the case, let us assume. But what happens now? How this accident has taken place, this knowledge is exclusively within the knowledge of the accused person. It is he only the better person who can speak how this accident has taken place. He has to say, even in spite of such a duty that is cast upon such accused person, if he remains silent, if he has not explained, then that is one of the major considerations for the Honorable Court while writing the judgment. I have already told that answer, if he keeps mum, adverse inference may be drawn. That may not be the sole criteria or the sole basis for conviction, but taking into assistance of that conduct, the court can, referring to other matters, it may proceed to convict the accused person. And you can take in a murder case, suppose I have already told, in an open ground if the murder has taken place, always the burden is on the prosecution to prove beyond reasonable doubt that it is these accused persons who have committed the murder of that particular person. So no burden on the part of the accused. But suppose the same murder, it has taken place in a room, in one bedroom, wherein it is an established, the evidence before the court that it is only the husband and wife, they were staying in that particular bedroom. If the murder has taken place in the bedroom of the wife, when the prosecution against this person under section 302 that has taken place, the evidence was adduced, all that has been taken place. In that case also, if he remains silent, what will happen? In this case, his silence, it will be considered very seriously, because section 106 of the Indian Evidence Act is very clear. Any factual, the knowledge which is exclusively within the knowledge of that accused person, it is he who is the proper person to speak what has happened, under what circumstances this incident has taken place. Under what circumstances this incident has taken place, it is for him to explain the things. Even in spite of such a duty, if he remains silent, then Supreme Court said it is to be taken into consideration, just it should not be ignored, and the adverse inference under the Indian Evidence Act under section 114 class G will have to be drawn against such person is also one of the consideration. Last time I have given one case law of the state of Maharashtra in the case of Trimukh Maruti Kirkan versus state of Maharashtra. One case in appeal criminal 1341/2005. And date of the judgment also I have given last time, that is 11/10/2006. And the name of the honorable judges also I have furnished to you last time, that is Honorable Justice Mathur and Honorable Justice R.V. Ravindran. And the same aspect what I am telling about section 106 of the Indian Evidence Act, that was discussed in that particular judgment. But I am also giving one citation of the recent judgment of the Honorable Supreme Court, dealing with the same principle, under section 106, because the incident in that reported decision also, it has taken place in a bedroom of the husband, wherein the wife, of course, the case that was projected is that she committed suicide. But the court, the Honorable High Court, it has taken into consideration after analyzing all the matters, and when it is an established fact before the court by way of evidence that it is only the two persons, husband and wife, they were staying in that room, it is for the husband to explain. Therefore, the court has to frame the questionnaire in such a manner, giving an opportunity to that the person. In spite of giving such an opportunity, if he remains silent, it is not the fault of the court. It is his own fault. If he wanted to remain silent, then in that case, what happens now? The silence of that particular accused person, it will be counted and it will be taken into consideration. But only thing is that about these things, there must be clear and specific questionnaire framed by the Honorable Court, and it should be read over to him. In spite of that, if he is not able to answer, then the matter ends there. This is also one of the considerations that we have taken into consideration. Now, the next question is, with regards to the language of this 313 statement is concerned. Supreme Court said it can be in English. 313 statement can be in English. But while reading this language, the questionnaire to that particular accused, suppose the accused involved is Tamilian. He knows only Tamil. He doesn't know English. But Supreme Court said it is sufficient. Let it be in English only. But there must be a true translation into the regional or the local language to that accused person, so that there may not be any difficulty for the accused person to understand the translated language in Tamil and what exactly wanted to say about the incriminating material that you have collected during the course of the evidence. If that is done, the Supreme Court said that this is more than enough, because the ultimate object is that he must understand the questions of the court. Therefore, the Supreme Court said, whenever you are framing the questionnaire for the examination of the accused under section 313 of the CRPC is concerned, you should not use the compound sentences. A simple sentence must be there. You should not use more facts in one sentence. Supreme Court also said that your questionnaire must be in such a way that even it is easily understandable by the layman. Even it should be easily understandable by the layman. There should not be any difficulty as such. Then only we can say that the object of providing this section for the examination of the accused is going to be fulfilled properly. Otherwise, using the compound sentences, putting more facts in order to create confusion in the mind, and if after reading this question, if he is not able to understand what the court is wanted to put before him by way of the incriminating material, in that case, what happens now? We can say that it cannot be said to be a proper examination of the accused person, and it cannot be said that there is no, it is without any confusion that you have examined this accused person. This is also one of the most important aspects which the courts have the oftenly in the judgments making the references about this aspect is concerned. This is another aspect. Now coming to another aspect of the 313 statement. Suppose there are more than 5 accused persons. One person is coming, and when he is examining, he is making the statements. And his statement is not only inculpatory of himself, it is inculpatory of other accused persons. Now, what is the evidentiary value of these things? Supreme Court said, such things, they are not binding on the other accused persons. At the most, it is binding on that particular accused who is giving the answers. And the answers given in examination under section 313 involving the co-accused persons also, it is not binding on such co-accused. It is only binding on the particular accused person who is giving the answers. Is also one of the important observations made by the Honorable Supreme Court in that particular case. Now coming to some important decisions of the Honorable Supreme Court regarding this aspect of the examination of the accused under section 313, you can take very important 3 decisions I have collected. If you read these 3 decisions on the aspect of 313 CRPC, everything will be cleared and absolutely there is no doubt in your mind how this examination is to be conducted, what is the scope and ambit of the section 313 of the CRPC. Very important decisions. You can take the decisions. Number 1, I have already told about this. What is the indication of the accused keeping silence? And I have already told that if he remained silent, adverse inference is to be drawn. That principle I have already brought to your knowledge. And to support this, you can please take the Supreme Court judgment. The citation is 2019 14 SCC, page number 438. It is a full bench judgment of the Honorable Supreme Court consisting 3 honorable judges, that is Honorable Justice N.V. Ramana, Honorable Justice Mohan M. Shantanagoudar, Honorable Justice M.R. Shah. 3 judgment, that full bench judgment of the Honorable Supreme Court. This case is in the case of Prahlad versus State of Rajasthan. Prahlad versus State of Rajasthan. And in this case, the accused, he was charged with 2 offenses. Number 1, 302, and second offense is 376 of the IPC, rape. And section 3 and 4 of the POCSO Act were also involved in that particular case. The factual story involved in this particular case is that on one day, the girl who is about the age of 8 years only, in the evening at about 4 p.m., she was playing with other children in front of the house. And the accused person in this particular case, the Prahlad, he came and he offered to this lady, the girl, that he wanted to give her chocolates. And because this person, he was treated as a family member of the informant, that is the complainant in this case. He was treated as a family member. Therefore, he often used to come to the house. And this lady, the girl was also having some sort of acquaintance with that particular person, accused. When he has called, then there was no reason for this small lady that to make any suspicion or raising any doubts. When he said that he wanted to get her chocolates, then she accompanied with that particular person. He has gone to a particular shop, taken the chocolates and some other eatables for that girl. Then subsequently what happens now, in the night, the girl did not return to the home. Then the father and other mother and other members of the family, they came and they made search here and there about the girl, but the girl was missing and she was not traced during that night. Then the lady by name Lali, which is used in this judgment, the name Lali, she informed to the family members that it is the accused person who has taken this daughter, that is a girl, and she has seen. This was told by Lali. Then the investigation started. The family members searched here and there. On the next day morning of the incident, the dead body of this girl of 8 years, it was lying nearby the house of one Nazi. Then they lodged the complaint at about 1 p.m. on the next day. Then the offences were booked under section 307 and 376 of the IPC. Then trial was conducted. Ultimately, the trial court convicted the accused person for both the offences. Then the appeal was preferred before the Honorable High Court, and even Honorable High Court also confirmed the conviction of this accused person for both the offences. And subsequently, when the matter was taken before the Honorable Supreme Court, the Supreme Court assessed this in detail, and so far as 302 is concerned, the Supreme Court confirmed the conviction order. So far as 376, when it was after the investigation and charge sheet was filed, this 376, it was converted into section 3 and 4 of the POCSO Act. And conviction was also there under the POCSO Act. Therefore, the capital punishment was given by the trial court. The capital punishment. When the capital punishment was imposed on the accused person, you know that the provision, it is subject to the confirmation by the Honorable High Court under section 366 of the CRPC. The judge, the trial judge who imposed this conviction and the sentence of the capital punishment, then he has to refer the matter to the Honorable High Court under section 366. By way of this reference, there is one appeal before the Honorable High Court, and the accused person, he also preferred the appeal seeking his acquittal before the Honorable High Court. Ultimately, what happens now, Honorable High Court, it allowed the appeal filed by this by way of reference, and confirmation was given for the capital punishment. But so far as the appeal preferred by the accused is concerned, it was dismissed for both the offences, and the trial court judgment it was confirmed. Ultimately, this is how the matter come up before the Honorable Supreme Court. But Honorable Supreme Court, after assessing the entire materials, it ruled in that particular case. So far as 302 offence is concerned, there is material and there is a concurrent findings of the courts below. Therefore, it was confirmed so far as 302. But so far as conviction under section 4 of the POCSO Act is concerned, the Honorable Supreme Court, it reversed the judgment of the trial court and it set aside the conviction under section 4 of the POCSO Act. This is why, because the Supreme Court refers to the medical report and also the oral evidence of a doctor who conducted autopsy on the dead body of this girl of 8 years. Of course, it was observed by the doctor also that there were some injuries on the person of the girl. Even the injuries are on the thigh portion and on the right elbow portion and also on the cheek. There may be some injuries. But when the doctor was examined before the trial court and when he was cross-examined, that it come up during the course of the evidence of the doctor that there were no injuries so far as the private part vagina is concerned. No injuries on the vagina. It was normal. It was healthy. And even the vagina swab was taken. It was sent to the chemical examination FSL. FSL report was also negative so far as the sperms are concerned. And there is no any sign on the thighs of that girl regarding the ejaculation of the sperm is concerned. Therefore, taking all these aspects into consideration, the Supreme Court said, except the say made by the prosecution orally that there is they not supported by any material to be believed by the court that even there is an offense of rape of this victim girl. Therefore, the Supreme Court, so far as Section 4 POCSO Act is concerned, it allowed the appeal of the accused person and set aside the judgment to that extent. And Supreme Court also converted this capital punishment into life imprisonment. Why? Because it said in its judgment, it is not the case wherein it comes under the rarest of rare cases. We cannot say it is a case under rarest of rare cases. And Supreme Court also said that it is not a case that it is a brutal murder committed by the person. Only the aggravating circumstance which has come on record as per the prosecution story that the accused has taken the disadvantage that he know and he is having the acquaintance with the family of that girl, and that girl was treating this accused person as a maternal uncle, mama. That was the advantage that he has taken, and he has taken the girl to some place and he has committed this murder. Therefore, the Supreme Court said when it is not a the murder, heinous murder or brutal murder, then only the life imprisonment will be the sufficient punishment, and capital punishment it was modified by the Honorable Supreme Court. But here our discussion is with regard to recording of the statement under Section 313. The Supreme Court said in that case, what the Supreme Court said here, when he was examined, the accused person, when the questions were read over to the accused person, he remained silent and he has not answered the questions. But here you please see, last scene theory, I have already told one lady, Lali, who informed the family members, she has seen that this accused person was taking away this girl. One evidence. Shopkeeper was examined, and shopkeeper said that I have seen this accused person who came with one small girl and he has purchased some chocolates and some other eatables. Therefore, there is an evidence about the last scene theory. When that is so, and when the questionnaire has been put about the evidence of these two persons, the accused did not explain. And there is no evidence. What has happened? What has happened after he has made the purchase of the chocolates? How he was departed with this lady? When? Absolutely, there is no answer from the mouth of the accused person. Therefore, the Supreme Court said, when he was compelled to give the answers to the questionnaire, when he was under the duty to speak about these incriminating circumstances are concerned, in spite of that, when he remained silent, his silence that we have to consider, and we can draw the adverse inference as against this particular person. This is how the Supreme Court taken the evidence so far as the offense under Section 302 of the IPC is concerned for confirmation of the conviction under section for the offense under Section 302 of the IPC is concerned. This is how Supreme Court appreciated so far as the accused person during the course of examination under Section 313 remaining silent, how it affects the accused person, because adverse inference is going to be drawn. And that is the reason that accused person, whenever reasonably he was asked, put the question clearly by framing the specific questions regarding the incriminating material. It is his bounden duty that he has to give the answer. This is one of the requirement, and the full bench judgment of the Honorable Apex Court, it will clear your doubts regarding how the examination is to be done, what is the scope and ambit of Section 313, and in this reported judgment, how this was exercised by the Honorable Supreme Court. This is all with regard to the particular judgment. Now we can come to another judgment. Yes. You can take the citation 2011 to SCC, page number 206. 2011 to SCC, page number 206. It is a division bench judgment of the Honorable Apex Court. And the name of the parties involved in this case is Sajjan Sharma versus State of Bihar. Sajjan Sharma versus State of Bihar. In this particular case, though in the trial court, the accused person was convicted, this appellant, there are many other accused persons. It is a case of murder by firing with a rifle. Case of murder, firing with the rifle in the land, wherein the complainant Mahesh Kumar and his uncles, two uncles, out of which one has been murdered by the accused persons. Therefore, the case was booked against the accused persons in this particular case about the offences under sections 302, 379, read with 34 of the IPC and under section 27 of the Indian Arms Act. These are the only sections. I have already told accused involved in this particular case were 7 in number. When they are 7 in number, the offense, either it is to be read with section 34 if the number is less than 5, or if the number is 5 or more than 5, the offense is also to be read with section 149 of the IPC. But it was not at all there, neither section 34 nor section 149 of the Indian Penal Code. It was a charge from the accused person. Therefore, Supreme Court said, wrong framing of a charge, and not properly examination of the accused under section 313. This is the fate of this particular case. And the courts below, the trial court as well as the Honorable High Court in this particular case, they have not at all gone into these aspects of the matter. Though there are many witnesses examined on the side of the prosecution, all major witnesses they turned hostile and not supported. And only the evidence, supporting evidence is PW5 and PW6. PW5 and PW6 are the witnesses examined. And so far as PW6 is concerned, Supreme Court appreciated his evidence, and Supreme Court said that what this PW6 has spoken before the trial court during the course of the evidence. No doubt he has spoken about the presence of the Sajjan Sharma also, that is the appellant before the Supreme Court. His presence he has spoken, but he has not assigned any specific role as such. What role he has taken, participated. And even there was no allegation that he was holding the lethal weapons in his hand. So the Supreme Court, after making observations so far as the oral evidence of this PW6 is concerned, Supreme Court said the evidence of PW6 is not worth believable. And now the another remaining evidence is the evidence of PW5. PW5 is concerned, the Supreme Court said, though he claims that he is the eyewitness, but his statement was recorded after 10-20 days. 10-20 days, there is a gap of the recording the statement by the investigation officer. No reasons are forthcoming. Then this delay has been not explained. Therefore, the Supreme Court said these aspects were not at all properly considered by the courts below, and they have wrongly proceeded to convict the accused person. Ultimately, in this particular case, the Honorable Supreme Court allowed the appeal, set aside the conviction order, and the accused person, he was acquitted in this case. Therefore, I have already told severe comments were made by the Honorable Supreme Court so far as the framing of the charge is concerned. You please, I will read the words used by the Honorable Supreme Court. Role of a judge. Framing of charge and examination of the accused under section 313 Cr.P.C. Laxity, especially in the state of Bihar, strongly deprecated, and High Court concerned directed to take corrective measures. Directed that a copy of this order be placed before the Honorable Judge of the Patna High Court in charge of the State Judicial Academy. This is how the Honorable Supreme Court made the observation in this particular reported judgment. That is the reason that I have already told. This examination of the accused under 313 cannot be taken as mere formality, the empty formality. It is having its sole purpose and significance. And framing of the questionnaire, not referring to the evidence, and only in one or two questions, simplifying it, not referring to the witness separately. Suppose if the accused are a different number, what is the role played by each of the accused is also that it requires a separate preparation and mental application and preparation of the questionnaire pertaining to the evidence spoken by each of the witnesses. If that is not done, if the stereotyped the statements are prepared, as I already told, in some cases we noticed that suppose about 10 witness, the accused persons are there, accused number 1's statement is recorded, then with regard to the other persons are concerned, signature at the below, keeping the questionnaire and the answers blank. Whatever the answers, it is not filled by the judge. Means after looking to the answers given by accused number 1, probably the judge wanted to fill up the answers columns pertaining to the rest of the accused person. This is also some of the courts that they were doing like that. It will defeat the very purpose of the inserting the section under section 313 of the CRPC for the examination of the accused. Therefore, courts must be very careful, particularly the role of the judge in preparing the questionnaire. But you see one provision, section 313 subclass 5, you please read that the particular the provision, what it says. The judge, honorable judge, while preparing this questionnaire, he can take the assistance of the prosecutor as well as the defense lawyer. There is no bar as such. The assistance can be taken while preparing this questionnaire. Then it can be read over to the accused person is also the provision under class 5 of the section 313 of the CRPC. Therefore, such the care, if at all it is exercised, then usually that it is useful to the accused, so also it is useful to the court also. Because when the court gets the clear answers from the accused person, it will be easy for the court also to deal with each of the material which has been through the mouth of the witnesses, and the judge can effectively meet it and he can pronounce more effective and satisfactory judgment in any criminal case is concerned. This is all what I feel necessary with regard to the important aspect of section 313 of the CRPC regarding examination of the accused. And so far as the summons cases are concerned, I have already brought to your notice. The proviso was added subsequently, and proviso provides some discretion to the judge that if he dispense with the personal attendance of the accused person, then the examination of the accused can also be dispensed with, and the statement can be recorded through the mouth of the counsel appearing for that particular accused. I have already brought to notice, and the observation of the Supreme Court in 2 judgments I have already given to you with citation and the name of the parties. But Supreme Court said this practice is to be deprecated. Always it is feasible, insisting the accuser personally has to come and personally has to give the answers to the questionnaire framed by the Honorable Court is concerned. This is all with regard to the section 313. And if you are having any doubts, you can please raise the questions.
Sir, the way you have took us to the entire journey of 313 coupled with the other sections.
Yes, sir.
And it's an excellent session. I don't think there will be any doubt, but still, yeah. Section 5, if assistance of defense counsel is taken, then questions framed would favor the accused.
No. Why that wording is used to take the help of the accused and they take the help of the defense counsel as well as the prosecutor in class number 5. Always the questions will be with regard to whatever the witnesses deposed. Only with regard to that you have to frame the question. That evidence is already in record. Where is the question of this learned counsel appearing for the accused making any favor to the accused is concerned? This is one aspect. Secondly, what I can say before you, framing the questionnaire is, I have already told, only with regard to the incriminating material of the accused person. Otherwise, suppose if there is no incriminating material, not necessary to frame the question at all. you know that suppose all the witnesses turned hostile. In that case, what happens now? While pronouncing the judgment in the CRPC, there are two sections. The court can dispense with the examination of the accused in case all the witnesses turned hostile, because there is no incriminating material from the mouth of any of the witnesses. Not necessary to examine him. Even if you are going to examine, what questions you are framing, there is no incriminating material at all. Therefore, there are two sections, 332, either 232 and 235. 232, what it says, if there is no material, no evidence at all, court can pronounce the judgment of acquittal immediately. But in 235, what happens now? There will be a material, but it is for the court whether to believe or not to believe. In that case, what happens now? All this exercise of examining the accused, framing the questions, and about the incriminating material, picking out that the particular the sentence from the mouth of the witness and putting him to the accused person, seeking his answers. Yes.
So we don't have this question. I'm just checking. Even on the Facebook, there are none. But I'm just checking it out whether we have any questions on the YouTube. No, sir. And so I'm quite sure the one question has just popped up.
Yes, sir.
Is 313 statement required with an affidavit?
No. Because I have already told the word personally that has been inserted. But the written statement is also provided under class 5.
Unmute.
Written statement, he can submit the written statement. Affidavit means it comes under that we have already read class 2 in section 313 subclass 2. No oath is to be administered to the accused person. Once you say that affidavit, then he has to swear.
Yes, sir.
Yeah.
We have unmuted Nitika. She wanted to ask a question directly.
Yeah.
Nitika, you can ask the question directly.
Hello, sir.
Yes,
this
sir.
is Nikita here from Bombay.
Yes, madam.
Sir, I would just like to have a little clarification. Suppose if during the proceedings of taking statement under 313 of the accused, if the accused is absent, then what report would the court file? What report would the court prepare? And what would be the further steps which would be taken by both the counsels as well as the court? Secondly,
madam,
yes, madam.
If the accused remains absent,
yes, sir,
then the court has to issue the warrant and secure his presence, isn't it? Because unless he come before the court, there cannot be any examination at all.
All right, sir.
He has to be secured under the provisions of the CRPC. That warrant can be issued and his presence can be secured before the court.
Right, sir. Sir, but here the accused has been absenting in one of the Negotiable Instruments Act since 2016, and the Ruknama simply depicts saying that waiting report.
Negotiable Instrument Act, check bounce case, you are asking about 138 of the Negotiable Instrument Act, madam?
Yes, sir. Yes, sir.
It's a summary proceeding. It comes under the summons case at the moment.
Yes, sir.
So in that case, what happens now? It is provided in the by way of proviso to section 313. The personal attendance of the accused person can be dispensed with by the court for the reasons if it is shown before the court, and the examination can be through the mouth of this the accused, the counsel who is appearing on behalf of the accused.
Right, sir.
So
Thank you.
Seriousness is with the seriousness of the examination of the accused personally is under 331 subclass 1 subclass B. There is a seriousness personal. The court has to insist the personal attendance of the accused person. And as you said, 138 summary proceedings before the magistrate court.
So the last question we are taking by Joban Kumar: when the examination of accused under section 313 is required to be done in an inquiry?
In
an inquiry.
In an inquiry?
Yeah.
No, because I have referred to 313 class 1 subclass small a.
Okay.
The court at any stage during the course of inquiry put questions without the prior warning of the accused. It can pose any questions. There what happens now, when the evidence itself has not been there, it is during the course of inquiry. Then the court, if you wanted to satisfy about the aspect of the case, the court can put the questions without the prior intimation or the warning of the accused, warning to the accused. There, what happens now? There is no question of examination under section 313 effectively as such. It is only during the course of inquiry that we are speaking. Class number, the subclass A refers to inquiry proceedings, not the trial proceedings. The words are very clear in the CRPC section. You please see.
Yes.
The words are very clear. It is only during the course of the inquiry, not during the course of the trial.
Yes. They can go through the Bail Act. They will easily understand, and the way you have explained it.
Yes.
So before we part for the day today, tomorrow the session would be on plea bargaining, evolution and development with the international perspectives also by Dr. Vijay Lakshmi, an assistant professor of SOIL, Tamil Nadu University, Ambedkar Law University, Chennai. Do stay connected with us at 4 p.m. And Sir's popularity is testimony of the fact that office is going on the lawyer's part, but on the Facebook, I've seen that it's done tremendously well, including on the YouTube. I will share the shots with you, screenshots. And thank you, sir. And it will always be a pleasure hosting you. Thank you, everyone. Stay safe, stay blessed. To all those participants who are watching us live on the Facebook, YouTube, and on this platform.
Sir, I'm grateful to Brother Vikas, and I'm also grateful to all the participants, my brothers and sisters, and I am thankful to Brother Vikas for giving me this opportunity to appear before you and to deliver the lecture on the subject under section 313 of the CRPC. Thank you, one and all.